So, hi guys, we'll be starting with state liability as of now. State liability. In England, the older position was that the Crown can do no wrong. Can do no wrong. It was eventually overturned by the Crown Proceedings Act, where the Crown was made liable for torts of some government servants. Right, that is one thing. Just a second. Yes. इसके कुछ केसेस भी हैं, वो भी मैं आपको पढ़ाऊंगा कि किस तरीके से ये चीजें पनपती हैं हमारे देश में भी और बाहर भी. राइट, इंडिया में क्या होता है? इंडिया में इट इज द आर्टिकल 300 विच रिकॉग्नाइज द पावर ऑफ द गवर्नमेंट टू sue एंड टू बी sued इवेंचुअली. We have to remember that in India, government is the largest litigator. इस सरकार के सबसे ज्यादा केसेस हैं, इस बात का ध्यान रखो. या पीएससी उसको भी इंक्लूड करते हुए. राइट. Traditionally, a distinction was made between sovereign functions, for which a state could not be sued, and non-sovereign functions. However, the modern judicial trend has blurred this distinction in the light of the changing nature of the state into a welfareist one and the constitution recognition of fundamental rights. The first Law Commission report also recommended, first LC, that the state should be responsible for the acts of his servants like any other ordinary employer. ठीक है, the employability का concept भी आ गया. कुछ cases है. First of all, P&O Navigation Company versus Secretary of State. It was the maintenance. It was said that the maintenance of dockyard is a non-sovereign function. Thus, the government was held liable. Apart from that, there was the case of State of Rajasthan versus Vidyavati. The Supreme Court in this case absolutely followed the decision of Justice Peacock in P&O. इसमें जो थे ना जस्टिस, वो थे Justice Peacock. Decision of Justice Peacock in the P&O steam navigation of case and held that government of Rajasthan is vicariously liable for the tortious acts of its servants. However, the Supreme Court did not delineate as to what amounts to sovereign functions. ठीक है, यहाँ पे भी क्या लिखता है? Functions of the welfare state is not confined to law and order alone. It engages in various commercial activities. Thus, it must be held liable for the tortious act of its employees in the same way the ordinary employee would. Then, Kasturi Lal versus State of Uttar Pradesh. Kasturi Ram Radia versus State of Uttar Pradesh. Jewelry impounded by the police from the plaintiff was stolen by the constable. It was held that police being a sovereign function, a claim for damage would not lie. However, the court itself noted that this position is untenable and needs immediate reform. So क्या हुआ था? In the case of, मैं लिखता हूँ, कस्तूरी लाल वर्सेस स्टेट ऑफ यूपी. कस्तूरी लाल वर्सेस स्टेट ऑफ यूपी. ठीक है. In this case, a particular quantity of gold was seized from the plaintiff by the police. Gold from the plaintiff by the police. Right. And was kept in police custody. It was misappropriated by the police constable. The plaintiff raised a complaint before government of Uttar Pradesh and argued that the loss was caused due to the negligence of police officer. The negligence of police officer was proved. ठीक है. The Supreme Court rejected the claim by the plaintiff and gave a more expansive interpretation to the words sovereign immunity. एससी ने फिर सॉवरेन इम्यूनिटी के कॉन्सेप्ट, सॉवरेन इम्यूनिटी का जो कॉन्सेप्ट है उसको एक ज्यादा एम्पलीट्यूड दिया, उसके स्पेक्ट्रम को बढ़ाया. राइट. इट ऑल्सो ऑब्जर्व देर इज no tortious liability of the state if the act was committed by the police servant in discharge of statutory function. अगर statutory function है, ठीक है, तो there is no liability, which is nothing but the delegation of sovereign powers of the state. ठीक है. लेकिन क्या यहाँ पे एक कांस्टेबल ने सॉवरेन फंक्शन किया था? नहीं किया था. नहीं किया था, चोरी करी थी, तो इसलिए लाइबिलिटी ठहराई गई थी. यहाँ पे केस में ये हुआ. Then we have the case of Nagendra Rao versus State of Andhra Pradesh. The food grain sold by the plaintiff were impounded by the police. By the time he was acquitted, all the grain had rotten. P claimed damages. The plaintiff claimed damages, held that the seizure of goods was not a sovereign function. Right, principle of विद्यावती's case was eventually followed. ठीक है, इसमें डॉक्ट्राइन ऑफ सॉवरेन इम्यूनिटी को ना एक और मतलब उसको एक्सप्लेन किया गया था. In Nagendra Rao versus State of AP, the doctrine of sovereign immunity was stated, and it was stated that it is having no relevance in the present day context because the context of sovereignty itself has undergone drastic changes. Right? The distinction between sovereign and non-sovereign functions is meaningless as of now under the tort law, which is prevalent these days. Then, sovereign functions क्या होते हैं? In recent cases, the courts have awarded damages for sovereign functions. There is this case of Basawa versus Mysore. It was held that after seizure, the state's position is that of Bailey. It had to pay compensation eventually. PUDR versus पुलिस कमीशन का एक केस था, कमिश्नर का एक केस था. State ordered to pay compensation for injuries caused to innocent victims as a result of indiscriminate firing by the police on a peaceful gathering. Sebastian Hongre versus Union of India का एक और केस था. The state was held liable for wrongful detention under AFSPA. Then Bhim Singh versus Jammu Kashmir, state was held liable for wrongful detention. Eventually damages were ordered. देखिए इतने सारे केस आपको याद नहीं रहने वाले, तीन चार रह जाए वही बहुत रहेंगे. ठीक है, बस जो एसेंशियल जजमेंट्स है ना, जैसे विद्यावती की जजमेंट बहुत ही एसेंशियल है, P&O नेविगेशन की बहुत ज्यादा एसेंशियल है. ठीक है, मैं यहाँ टिक लगा देता हूँ. ठीक है, तो इनका ध्यान रखना, तीन चार ध्यान रखिए, कैसे उससे ज्यादा किसी को भी नहीं याद रहते हैं. ठीक है, जैसे मैंने आपको जस्टिस पीकॉक का नाम यहाँ पे बताया है, अगर वो आप लिख देंगे तो अपने आप एग्जामिनर को पता लगेगा कि आप यार ज्यादा पढ़ के आए हो. वो गेम है, उसका ध्यान रखना है. आई होप यू लाइक द वीडियो. सी यू इन द नेक्स्ट क्लास. बाय.